I welcome you, dear students, to the lecture today on the regulation of use of force, to the questions of self-defense, to the resort to war. In the lecture today, we will try to understand that how treaty laws regulated the use of force. What is the current status of treaty law with regard to the use of force in relations among states? How far the treaty law has been successful in subjecting, in controlling the war itself, the violence in the life of society of states. League of Nations laid down the provisions to regulate the use of force. It did not declare the war as illegal. It recognized the use of force as the right of the states. First attempt. After 1920, the attempt in this regard which was made was in 1928. In 1928, a treaty was signed, popularly called as the Kellogg-Briand Pact. It is officially described as the General Treaty for Renunciation of War as an Instrument of National Policy. General Treaty for Renunciation of War as an Instrument of National Policy. I am repeating just to make you understand that war, as I said before, the League of Nations was unquestionably used. There was no renunciation of it. League, though, tried to regulate it, managed it, that it should not be an open use of force. But this treaty, from the name, official name, it could be made out by you that it renounced the use of force. It de-recognized the war as an instrument of national policy. The pact had 63 states. The parties concluded outside the League of Nations. This structure, this treaty, still remains in force. Signatories to this treaty declared that they condemned recourse to war and agreed to renounce it. Agreed to renounce it as an instrument of national policy in their relations with one another. This fact is postulated by Article 1 of the treaty. They also agreed that settlement of disputes arising among them shall ever be sought to be pacific means, shall ever be resolved through pacific means. Article 2 of the treaty lays down the pacific settlements of disputes. This treaty did not declare war as illegal. It also recognized the inherent right of states to self-defense. It served as a legal basis for the concept of crime against peace and for the trial and the execution of wartime German and Japanese leaders in 1946 during Nuremberg and Tokyo trials. The pact was a realistic and comprehensive legal regime. At the time of Nuremberg trial, the defense which the German had taken at the time of prosecution after the First World War, that was not accepted because Germany itself was signatory to this treaty. So this treaty became a source for the prosecution of Germans, those who were held responsible for the Second World War. And accordingly, being party to this treaty, they were punished. This also happened with these two treaties could not prevent the outbreak of this Second World War, but they laid down the treaty-based regulatory mechanism to define war as something unacceptable, and acceptable only in special circumstances, not as an instrument of state policy. Instrument available to states to resort to war, to violence according to their whims. With the founding of the United Nations in 1945, the legitimacy of the use of force by individual states under treaty law has been substantially narrowed down. The preamble of the UN Charter reads that we, the peoples of the United Nations, determine to save the succeeding generation from the scourge of war, which twice in our lifetime has brought untold sorrow to the mankind. One of the first goals of the United Nations, consistent with Article 1 of the UN Charter, is to establish international peace and security. We all know this fact that the United Nations was created for establishing international peace and security. This was the defining overall purpose of the United Nations. The present legal framework regulating the use of force in international law actually is enshrined in the Charter of United Nations. Various provisions provide for the regulation of war. For the discussion today here, the important thing is that we have to talk about the most relevant one, which directly deals with the regulation of warfare, resort to force, is the Article 2, 4. Article 2, 4 is regarded as a principle of international law and as such is binding upon all states. This is in fact the cornerstone of the Charter of the United Nations. Article 2, 4 stipulates that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. As the wording of the article suggests, the force is permissible in circumstances consistent with the purposes of the United Nations. Kofi Annan, the former Secretary General of the United Nations, at the time of the 2003 Iraq conflict, has written that no principle of the Charter is more important than the principle of non-use of force as embodied in Article 2, paragraph 4. Secretaries General confront many challenges in the course of their tenures, but the challenge that is tests them and defines them inevitably involves the use of force. So Articles 2, paragraph 4 is actually the defining feature of the Charter of the United Nations that regulates the use of force. This prohibition is also the defining part of other treaties and agreements. In 1970, the Declaration on Principles of Law of Nations concerning friendly relations, there is a general prohibition on the threat or use of force. It creates the duty for all states to refrain from organizing, instigating, assisting, or participating in acts of civil strife or terrorist acts in other states, or accepting in organized or tolerating inorganized activities within its territory. When these acts involve the threat or use of force against another state. In Nicaragua versus United States of America, International Court of Justice, one of the main organs of the United Nations, prohibition on the utilization of the force is proof of treaty law. That is the UN Charter by the customary law of nations. In Nicaragua versus the United States of America, the International Court of Justice, one of the main organs of the United Nations, held that prohibition on the utilization of the force is proved by treaty law, by the customary law of nations, and therefore the prohibition was a just cogence norm. ICJ, International Court of Justice, has played a central role in development of international law on the use of force. Its role has proved extremely controversial, extremely useful. Overall, the International Court of Justice has taken the clear view that the prohibition on the use of force under Article 2 of the United Nations Charter is a strict one, and it has resisted calls to widen its view of the scope of self-defense, the scope of use of force in the justification of self-defense. It has been consistent in its approach to the use of force. It has repeatedly referred to its judgment in Nicaragua and has reaffirmed its finding in that case. The issue of right of self-defense is a serious issue. Right of self-defense are often both individual and collective. The right to self-defense is found in the Treaty of the United Nations. Article 51, dear students, provides for a member state to use force either individually or collectively in self-defense when there is an armed attack against the state. The condition is laid down here. The right of self-defense is not open. The United Nations Charter has conditioned it. It states, Article 51, which provides for the self-defense, right of self-defense to states. It stipulates that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to take care of international peace and security. Measures taken by members within the exercise of this right of self-defense shall be immediately reported to the Security Council. This is the condition, that it recognizes the inherent right, but at the same time, it subjects it to conditions. The condition is the right of self-defense. The use of force in self-defense arises only when the victim state is actually under armed attack. And when this is the situation, this right could be exploited, but the secondary condition is that the state has to inform to the Security Council so that the Security Council can take the appropriate measures. This is the limitation which the UN Charter imposes on the right of use of self-defense. The question is, the right of self-defense, the use of force in the light of this right is consistent with Article 51. An armed attack has to have occurred against a member state. Self-defense is only available against the aggressor, against the state which has attacked, which could possibly be categorized as the aggressor. The one who carried out or on whose behalf an armed attack was undertaken. This is the situation. The Charter refers to the two, though not unrelated circumstances in which the prohibition does not apply. First, forcible measures may be taken or authorized by the Security Council acting under Chapter 7 of the UN Charter. Secondly, force may be used in the exercise of the right of individual or collective self-defense as recognized under Article 51 of the Charter. Despite this recognition, despite this provision, use of force is not open in all situations. It has been conditioned, and that condition actually becomes in certain situations questionable, that what constitutes armed attack. Treaty law, UN Charter is quite clear about it, that what is armed attack. At this contrary, the customary law provides a different framework where the armed attack is looked differently. The self-defense is defined more generously. There are restrictions which are imposed by the treaty law, in customary law, they becomes questionable. But as of the League of Nations, the regulations which has imposed, this has made the war unacceptable and has put it to a regulatory framework where states have to justify their actions in the framework of the United Nations, the charters of the United Nations, which has actually laid down the various kinds of the conditions on the use of force. So this is the case with the use of force, right of self-defense, and despite the fact that the United Nations has imposed regulations through its charter on the use of force in relations among states, this remains a contested issue, and this will remain a contested one, because there are always questions which are political in nature and which cannot be legally defined, or they cannot be in legal terms made a law which states in their practices not accord acceptance. So I end here, dear student. Thank you.